Hello friends, my name is Ismail Shahtakhtinski and I'm the principal immigration attorney at ISLAW firm. Today I want to talk to you about the topic of asylum and military service, whether evasion from compulsory military service can be basis for asylum in the United States. We're quite often contacted by individuals in the United States who do not want to serve in their country's military, and they're asking if that could be basis for their asylum. So according to the international law and according to the US law, every country has rights to demand to have a mandatory service from its citizens in their military. And just the unwillingness to serve in militaries typically is not basis for asylum. But there are exceptions. One of the exceptions is if the actions of the military of this country, of the applicant's country, are condemned by the international community, if they are recognized as criminal acts. For example, the current situation where the current Russian aggression in Ukraine is condemned by the international community, and the actions of the Russian army in Ukraine are considered as criminal or even terroristic acts. So in that kind of scenario, the unwillingness to serve in the military of that country may be recognized as basis for asylum, but with one caveat that the applicant must have made their unwillingness to serve known, and the reasons behind their unwillingness to serve known should be the opposition to this war or to these acts of this government. So this opinion of the applicant must be public. It doesn't mean necessarily it has to be made directly face to face to the state actors who are trying to conscribe, to recruit this individual to the army, but to the military, but it has to be at least made public. It could be made through social media, so the applicant, for example, may have expressed their views through social media opposing the actions of this government or of this military, of this army, and they oppose this, and they are not willing to serve in this military. And if the actions of the government in trying to punish this applicant, who is in their eyes is evading the military service, must be related to this opposition to the military service. The other exception that I'm quite often asked about, whether unwillingness to serve for religious reasons could be basis for asylum, and the short answer is yes, but again with the caveat that the the religious bases have to be demonstrated and proven that those are genuine reasons, that the genuine religious opinions of the applicant prohibit the applicant from serving in military, and in what way, whether for example, some of the religions prohibit killing, or the applicant may not be willing to take arms and to fight in the war. But there is also alternative type of service. So the applicant has to at least demonstrate that they tried to demand alternative service in military, whether as a paramedic or whether they wanted to be a radio operator or in some kind of civilian capacity. And if that did not work either, then maybe there is a basis for asylum. But the U.S. Immigration courts, asylum offices, and federal circuit courts are usually very skeptical, unless very for cases of military service evasion, unless there are very specific facts and very bulletproof evidence that this this country's actions are internationally condemned, and that the applicant's unwillingness to serve is genuine and publicly known. If you have specific questions about your case, there are lots of caveats, and there's lots of nuances that you would want to discuss with your attorney. But please contact us. There is contact information, the links below, and we will be glad to listen to you and tell you whether you have a basis for asylum or not. Thank you for listening, and have a nice day.